Welcome to In Depth with Ellenoff here at Crowdsourcing.org. This is our regular podcast where we interview Douglas Ellenoff of Ellenoff Grossman Schole, and we discuss the latest matters over at the SEC related to equity crowdfunding. So this is the first edition of the 2014 In Depth with Ellenoff podcast series. So welcome to our readers to the new year. And Doug, glad to have you. How was your New Year's?
Well, Anton, thanks for asking. It was a fun New Year's with lots of travel. Ending up, as you and I have talked about, the first part of the new year in the Aspen crowdfunding event, which was a fun event and lots of new people. So I think we're off to a great new year in 2014 for many of the provisions under the Jobs Act. And I hope you had a good New Year as well.
I did. Thank you. And that all sounds great. So the topic that's been in vogue over the last couple of weeks has been the proposed rules by the SEC for the Regulation A+, the new provisions that are supposed to sort of alter the existing Regulation A regime. So can you just start off by telling our readers a little bit about the old Reg A raises and why you think the Congress felt that they needed to be tweaked so that these so-called so they came out with these so-called Reg A plus rules. And for example, one thing I read was that there are only 8 Reg A raises in 2012. Can you also discuss why these are so uncommon and was getting them to be more common part of the Congress's mandate in the Jobs Act?
Sure. And did you say they were 8 in 2012, or did you mean 2013?
I think I read 2012, but
okay.
Yeah.
Fair enough. Well, the interesting thing is that Reg A has been around for quite some time. It's not a new way of raising money under the securities laws. Reg A has been, as you said, up to $5 million of financing, exempt from the ongoing reporting of the 34 Act, but a registration statement filed with the SEC and reviewed by the SEC nonetheless. They allowed an issuer to raise up to $5 million and generally solicit, not unlike 506A, from investors, but in the case of a Reg A offering, not just accredited investors, but unaccredited investors. And notwithstanding that it's been on the books for quite some time, you're saying there were 8 done in 2012, and that's probably only because of the enthusiasm for what was going to come with Reg A+. But in my years of practice, we have very limited exposure to Reg A offerings getting done. I think, in many of the years prior to year 2012 statistic, there was maybe 1 a year done. So it's not a financial mechanism that many people have found to be interesting. I think there is a cross-section of the broker-dealer community and the conventional capital markets that if $5 million was actually $50 million, thus the proposed rule change, that more established financial intermediaries would find the registration interesting as a means for raising money for entrepreneurs, and that's why it became Title IV of the Jobs Act.
I see. Got it. Thank you. So one of the provisions I read about in the proposed rules mentioned sort of testing the waters material to go out about a raise. What does this mean on the ground for issuers, and how similar or different is this from the general solicitation, actually finalized rules that are already in effect, via Title II of the Jobs Act?
Sure. Well, Reg A Plus, as proposed and unanimously voted into as a proposal by the SEC commissioners, would enable an entrepreneur to raise up to the $50 million that we talked about. And the testing of the waters provision you're referring to gives an issuer, an entrepreneur, flexibility before actually undertaking the full registration process with the SEC under Regulation A, which is an involved disclosure about the company and its affairs, to submit to the SEC solicitation materials that would allow them to go out to investors, both accredited and unaccredited investors, to see whether or not they have any interest in investing in the particular opportunity before they spend all of the money on the Reg A filing. A Reg A filing is a much more involved process than a 506C general solicitation, which is a private placement exemption. It's not a registration, like a Reg A offering, which I think the folks are just starting to appreciate the expenses that it takes to do it will take to do a Title III crowdfunding to unaccredited investors up to $1 million. How it may be less to do a Title II private placement to accredited investors, and now we have Reg A Plus that is actually an involved regulatory filing, which is reviewed by the SEC. And while it has the benefits of raising up to the $50 million as opposed to the old standard of $5 million, and this is more than Title III, the up to $1 million, although Title II is an unlimited amount of money, the transaction-related expenses in a Reg A offering that will now allow you to raise up to the $50 million for both accredited and unaccredited investors, and have a security that is publicly tradable. It's a registered share, unlike 506B or 506C or Title III. These are going to be registered shares, but the transaction expenses will be much higher. And there are two tiers in a Reg A offering, Anton. There's the old standard up to $5 million where you don't need audited financial statements. They can be reviewed, but it's still a registration process, and that's going to be meaningfully more expensive to conduct than the other Jobs Act provisions that we've referred to. But if you want to raise more than the $5 million, the SEC has put into its proposed rules that you have to have audited financials, which will be more expensive, which is one of the reasons that above $500,000 in the Title III provisions will cost more to conduct, because there too, audited figures will be required. You have to put each one of these pathways to raising capital up against one another to see what are the benefits to you. Up to $1 million in Title III, unlimited in Title II, 506C, and up to $5 million in a Reg A deal, unaudited, above $5 million up to the $50 million, audited. You also get registered shares. So there are a lot of distinctions, there are a lot of choices, and for every entrepreneur, they will look at each one of these means of raising capital differently. So it's exciting.
Definitely. Now, one thing I've spoken with some platforms and entrepreneurs about is actually combining, both Title III unaccredited investor crowdfunding with, general solicitation enabled Title II accredited investor crowdfunding, and sort of combining those so that an entrepreneur could raise over $1 million per year. Now, that sounds like it would be expensive. So is this? Do you think they would? Do you think a lot of entrepreneurs are going to look at A plus as a potentially very viable alternative to combining those two, the Title II and the Title III?
To address your first point, you're correct that there are a lot of folks who are trying to figure out the proper mechanisms for doing what we call side-by-side investments between a Title III deal and a Title II deal if you need more than $1 million. But you also, people are doing it because they want to not raise more than $499,000 in the Title III offering to avoid that audit, and as the proposed rules say, annual audit responsibility in Title III. So if you only go up to the $499 level, your financials only have to be reviewed, and if you then do a side-by-side Title II deal and you raise more money and the offerings are not integrated, assuming that you follow the rules properly, that is a way of raising money for both accredited investors, the Title II, and the unaccredited through the Title III campaign, and raising more than the $1 million cap in Title III. Whether or not all of those related expenses will even come close to, in my judgment, to what the expenses involved in conducting a Reg A offering of our regular practice, do a lot of registration work with the SEC, and it's time-consuming and costly. And so I think those are two variables, uncertainty of time and more cost, that a lot of entrepreneurs don't have the upfront ability to pay. And so while I think that there is a home for Reg A deals, I'm not sure that it's competing per se with the side-by-side financings you were talking about as contemplated by doing a joint Title III and Title II deal.
I see. So I know a lot of people in the comments on the SEC's website have been calling for the commissioners to raise the $1 million per year investment limit for Title III crowdfunding. So some people have said that the proposed Reg A plus regulations effectively do that, but that's sort of oversimplifying things, is what I'm hearing you say, right?
I think that's right. I do think that each one of these new ways of facilitating capital formation under the Jobs Act, Title II, III, and now IV are all quite different, and in some cases they will interact. So, for example, I can see the value of doing a Title IV Reg A plus deal. So let's say you want to raise more than $5 million because you have an opportunity that needs that money and is profiled appropriately that there's enough interest to raise more than that money. You will now raise the money, so you're willing to spend the upfront money necessary to get through the Reg A process. It's above $5 million, so you have an audit. You also, pursuant to the proposed rules, now preempt state law, which is interesting. One of the things that people like about Title III is it preempts state law, except for enforcement purposes, so you don't have to pay all the blue sky fees except in the state in which you're incorporated. Title II doesn't preempt state law, so you have to do all the blue sky filing. In the proposed rules under Reg A, you have to file blue sky, but NASA, which is the umbrella organization for all state securities administrators, have come up in anticipation of the Reg A rules a coordinated review of the Reg A materials below $5 million, and above $5 million, it preempts it. So if you're able to conduct a Reg A offering, raise more than $5 million, you now have a registered security, you've raised more money, and you could now have your securities much more fluidly trade in a secondary market in a way that might have happened on Shares Post or Second Market previously, and there are other secondary places to trade securities, I think there'll probably be a home on the OTC market for those shares to trade, unlike in Title II or Title III, where after the year holding period, those securities they'll be transferable whether or not an active market actually occurs. But with Reg A shares, they're freely tradable except by affiliate of the issuer.
Mm-hmm. Yeah, that's very interesting. Now, so continuing to speak about the investor side of things, at least as far as you can tell, obviously it's difficult to say because neither Title III nor Title IV are actually finalized. But do you see any changes on the investor side? Both from the accredited and unaccredited investor standpoint. Are there any limitations, any differences between these proposed Reg A plus rules versus Title III rules?
Well, I was pleased to see, because I think imposing, in exchange for some of the benefits that you're getting for some of the Jobs Act provisions, I think the SEC in an enlightened way is superimposing in Title III and IV, although not in certain instances in Title II, which they didn't have the flexibility to do, truthfully, although I think it would have probably been, had some wisdom associated with it, which is to have suitability type standards imposed on how much money an investor can invest in any particular deal. So in Title III, we have the $2,000 cap, or if you make more than $40,000 up to $100,000, it's a 5% cap, similar to your net worth as well, and then it's a 10% cap above that. In Reg A, plus, the commissioners have approved a 10% cap on how much you can invest in a Reg A deal. So that's a provision as it relates to the investors.
Mm-hmm.
But going back to one thing you said, in Reg A, even though there's a lot of commentary on raising the $1 million cap in Title III, the SEC is hamstrung there because Congress put a $1 million cap in there, and so not that I think the SEC would change it, even if it weren't a $1 million cap that was required of them under the actual statute. The statute does cap it at $1 million, and so I don't think they have the flexibility without congressional action to change that number.
Mm-hmm. Mm-hmm. Got it. Okay, great. So I think that's an interesting conversation about Reg A Plus there. I did want to ask you a little bit about the Aspen conference you were at. Any interesting takeaways from there? What's being discussed on the conference circuit these days?
Yeah, I'm glad you asked. As I was sitting next to Sherwood Neese, who presumably many people who are your listeners know who he and his partner Jason Best are, who are took the leadership role in actually getting the Title III crowdfunding provisions through Congress. They Sherwood was at the conference, and we sat there and we listened to a couple of data points that I think are important for your listeners to really appreciate how far we've come in a year, even though people get frustrated that certain things haven't happened or haven't happened as quickly as they might like. Actually, three things to note. I mean, one data point I'll point out as it relates to Title II as an example is that as of the last I looked, which was probably a week or so ago, on AngelList, you have 4,500 companies posted on their site, generally soliciting as we speak as a result of the September 23rd Title II provision going into effect. That is a large number of companies. I think that's significant. When I was down at the SEC speaking, somebody from the SEC shared a statistic, this is probably going back a month or so ago at this point, that since September 23rd, there were a couple of hundred deals that raised over a couple $1 billion pursuant to the Title II general solicitation provision. I think those numbers are polluted for a bunch of different reasons, but you're still starting to see real momentum for people availing themselves of the Title II provision. In Title III, you had a couple data points that I think are noteworthy. One is that Our Crowd, which is an international crowdfunding platform under Title II, they have entered into a relationship with General Electric Venture to look at all the deals that are coming out of Israel. So I think that that's significant. And then the last point was I sat through a presentation where a serial healthcare entrepreneur who has always raised money from corporate sponsors and the traditional venture firms sliced off a piece of his most recent deal that was sold or placed through a Title II platform called Health Ventures. And so you had a hybrid deal, part corporate sponsored venture deal, also coupled with a Title II venture-backed financing. And so those three data points suggest to me that you have two worlds that are starting to better appreciate how to work together. The traditional sources of capital, the VCs, the corporate, and now the entrepreneurial sources of capital through these Title II campaigns. And when that also combines with Title III and now Reg A, plus there are just so many people looking at the world in so many interesting ways. How they all configure ultimately is what's going to be interesting and make each one of these new methodologies quite exciting for entrepreneurs.
Oh, for sure. Yeah, all very interesting points. Thank you for sharing, Doug. Okay, well, I think that's those are all the questions that I had. So thank you once again for taking the time to speak with me and share your wisdom with our readers. Obviously, very interesting conversation, and I hope to speak with you soon.